Okay, tape is rolling, coming up in 60. Sandy, that paper, bend it the other way.
Who?
The paper keeps picking.
Mine?
Yeah. Rebend it backwards. We're on black, 30-second. Ten seconds to title.
This is Speak Up. I am Sandra Schulte. Welcome back to our show. Today we have Joel Siegal back with us. Last time he was here, he spoke about divorce. This time he's going to talk to us about the issues involved in child custody. He is a partner at Hellring, Lindemann, Goldstein and Siegal, located at One Gateway Center, Newark, New Jersey. He was admitted to the bar to practice in both New Jersey and also in New York. He received his undergraduate degree from the University of Pennsylvania and his law degree from the very prestigious Yale Law School. He was judicial clerk for Judge Arthur S. Lane of the U.S. District Court of New Jersey. After that, he was judicial clerk for Judge Philip Foreman of the Third Circuit Court of Appeals. He was attorney in a very, very interesting case which had wide coverage, which was called the Mary Beth Whitehead case, and involved the famous Baby M litigation, which involved a surrogate parent and also visitation rights for a surrogate parent. Mrs. Siegal, what is a surrogate parent?
Well, that's a good question. A surrogate parent is someone that agrees, a woman, to bear the baby.
You mean rent a room?
Yes, well, I guess so. You want to put it that way. But there's all sorts of types of surrogacy. But in the Baby M case, the wife was unable, because of various reasons, to have children, and her husband, and incidentally she was a pediatrician, and the husband had a PhD, I believe it was in chemistry. He donated his sperm to Mary Beth Whitehead, and they went through this surrogacy proceeding, and eventually she bore a child.
Could it also be a case where they also, shall we say, use the surrogate parent's egg as well as her womb?
I believe so. When the Baby M case was in the mid-1980s, and we're now many years after Baby M, there's various procedures and offshoots and different ways in which you can do this, but at that time, the surrogacy was usually done by the male sperm being contributed to the woman, which in fact was a painful procedure. And I don't know why it was painful, but the surrogate mother who performed this task, it was not an easy task, whatever procedures they used.
Mm-hmm. As a result of this case, the New Jersey Supreme Court outlawed surrogacy. It also directed that Mrs. Whitehead should be afforded a trial to decide whether she should be allowed visitation rights as regards baby M. Mr. Siegal represented Mrs. Whitehead in that trial. The court awarded her visitation rights, but Mr. Siegal is going to talk about this a little later on.
Okay, and by the way, when we're saying surrogacy is outlawed, it's not outlawed on a volunteer basis. In other words, if the sister or the brother or somebody wants to be helpful in that regard, that's okay. What was outlawed essentially in New York and New Jersey, not in all states, was you can't pay someone.
You can't pay to play.
Yeah, that's it. You can't pay to play anymore. That was the Supreme Court. That was the law they made, and it's sort of the law in New York also.
Yes.
It's clearly the law in New Jersey, but it's also the law in New York.
No pay. What does sole custody and joint custody of a child mean?
Okay. There are two forms of custody, really. One is legal custody. People get divorced. Now, who has legal custody? Years ago, whatever that means, the mother usually had legal custody. And legal custody means that you have the right and the obligation to make all important decisions about religion, about school, health care, friends, the important decisions affecting your child. And in the past, it was ordinarily the wife, the mother. That has changed. And she had sole custody. And there's also something called residential custody, and all the residential custody means the principal residence of the child. Legal custody is what's really important, decision making, and residential custody just means the principal address. The only time that really comes into play, I guess, is with letters and correspondence, and sometimes if a wife wants to move out of state, that makes it a little easier for her to argue, well, I have residential custody, child lives mainly with me, but the big deal is joint custody, which is now very popular in New Jersey and New York. It became much more popular, or the presumption was it would be joint custody, and eventually New York agreed with that, and the law really, it's not that much different between the two. And when you have joint legal custody, that means the husband and the wife have to jointly make the important decisions. And sometimes that's difficult to accomplish. And even though theoretically the philosophy behind joint custody is the two parents are going to get along, but even where they don't get along, it's my observation, the courts still like the idea that joint custody gives the father a certain amount of dignity. He's equally responsible for making the important decisions, and so and it's really the right to make the important decisions.
I can just imagine them living in court for 18 years.
Well, no, it doesn't happen that way because, pragmatism. People don't want to spend their time or the money with regard to court. It makes the parents, get along. Well, I want to send Joey to XYZ summer camp. And the husband will say, well, maybe I like ABC camp. But then they get along. It forces people to get along, and I think it's very, very important that both the husband and the wife, the mother and the father, be involved with a child. So I think joint custody is a good idea.
What do the terms parenting time and visitation mean?
Well, the common expression is visitation, that the husband gets visitation. When does he visit with the child? But in order, again, to give the husband's dignity, they don't use that word anymore. They say parenting time. The wife has this parenting time, the husband has this parenting time. there's really, and it's very progressive now in the courts. They don't view necessarily the mother to be the more important person. You're not supposed to look at the sex of the parties. Some of the older judges, I think, sort of do, and there used to be a doctrine called tender years, where when a child was young, it was assumed that the mother should be involved more. It's not that way anymore. You go into court, everybody's equal. It's politically correct now to do that. And parenting time, you can go to mediation, or the parents can decide it, you can negotiate it. Sometimes it's not easy to decide it. Typically, the husband may have alternate weekends, Friday through Sunday, but then there's arguments who delivers the children Monday morning. And if it's convenient, I think the courts favor that now. At one time they didn't. And also dividing holidays equally, the summer equally, and during the week, husband normally would be able to take the children out to dinner, but the husbands fight for overnight. A lot of the judges don't like that because they think the child should have a certain place of residence, doing homework, where his books are, and so forth. But if the husband lives close by, some of the judges will divide the time 50-50.
2 sets of books. Is there any great difference between New York and New Jersey in that regard?
I don't think so. I think a few years ago, New York wasn't as sensitive to having joint custody where they had in New Jersey, and maybe more than a few years ago. But now that's sort of it. And client may come to you and say, well, he's no good. I have to make the decisions, and I don't want any of this joint custody. It's very hard to achieve. You'll say to the client, that's really not the law now. You're going to spend a lot of money. It's really an uphill fight. If one parent has, takes drugs or is violent, then you can get sole custody. But you're not going to get it generally. Otherwise, it's a fight that you're going to lose. And the argument then comes down, if there is an argument, about the number of days, and what ages. But you could fight very hard for days, but when I was last year and we talked about divorce, I mentioned how people fight for the days, and then 6 months later you get a call if you have the wife, he's not using all his days. Make him use his days. So that can occur. It's pride, it's dignity, and all of that also.
I'm sure our listeners are curious about what happened in the famous Baby M case.
All right.
Well, what happened?
It's a very interesting case, and I was not the original attorney when Mary Beth Whitehead was brought into court, and the Stearns wanted to enforce the surrogacy agreement. I came in later. And in the first case, I represented the grandparents who wanted visitation. But let me go through the history a little bit. I think that's the best way.
Start from the beginning.
And it's really very fascinating. I have a few notes I may have to refer to. But in March of 1984, there was an advertisement in the Asbury Press, and it said, I'm paraphrasing now, that they wanted volunteers to be a surrogate mother, and for those duties and obligations, you would receive $10,000. And Mary Beth Whitehead read that in the Asbury Park Press. She lived in New Jersey at that time, and they signed her up. and she, by the Infertility Center of New York, which was located in 60th Street in New York. And this is what they did. And when she went there, they gave her a test. And there was a report. And the report, I'm quoting now, stated, she expects to have strong feelings against giving up the baby. It would be important to explore with her in somewhat more depth whether she will be able to relinquish the child at the end. However, the Infertility Center never told Mary Beth about the report, which in the end we sued the Infertility Center of New York for failing to disclose that very important information, and we settled the case with Mary Beth receiving a sum of money for the settlement. So I did represent her in that lawsuit also. But in any event, she did not succeed at first to be successful in the surrogacy with, for whatever reasons, wasn't working out. And she was traveling by bus to New York all the time, and it didn't work out. But then they got somebody else, the doctor and Mrs. Stern. Mrs. Stern, incidentally, was a pediatrician, which I may have already mentioned. And it worked. And in fact, the Sterns and the Whiteheads, even though they came from different social backgrounds and so forth, were friendly. Mary Beth, in my view, very much wanted to do this, not because of the money. She felt she could contribute to society. Her father was a school teacher. He had various master's degrees, and Mary Beth left high school at age 16, but she was very innately bright. And this was for her a contribution, and she didn't get any money in the beginning, and she traveled from the bus to New York City and back all these times, and it wasn't succeeding. But then it succeeded with the Sterns, and this was about 2 years after she signed up with the Infertility Center of New York.
Sounds like a horror.
Yeah, and as she became more pregnant, and the baby was kicking inside her, I'm paraphrasing with things that she said, that she didn't think she could give up the baby. She became very upset.
Yes.
And in or about, I think it was in March of 1986, 2 years later, the baby was born. Now, when you have surrogacy, it's well known that you should immediately take the baby and not even let the baby be with the mother. But they didn't do that. That was a big error. So she was having this little baby. She was even nursing the baby, which was taboo. I mean, that was the worst thing in the world to do. This wasn't the fault of the Sterns. It just occurred in the hospital. And the Sterns visited her and so forth. And at that time, she desperately didn't want to give up the baby, but she did. I think she went in on a Friday, and I think on a Sunday, or it was a Monday, she gave up the baby to the Sterns. And she went home, and she became very depressed at what she had done. And she visited the Sterns and said, "You have to give me the baby for a week." She may have even implied she'd commit suicide if they didn't do that. And the Sterns, who were overjoyed that they had a little girl, now said, "Okay, but you got to return the baby in that week." And of course, that was another error by the Sterns, because Mary Beth, when she got the baby, wasn't returning that baby in 1 week. And in fact, she didn't want to return the baby at all. They had some conversations. She said she's a natural mother, and she's sorry. The Sterns went through all of this. She felt badly about it, but she was not giving up this baby. She already had 2 children, by the way. And the Stearns went to court and they obtained what is known as an ex parte order. They didn't give any notice to Mary Beth that they were going to court, which the Supreme Court later criticized the judge for signing the order. And the order was to turn over the baby to the Stearns. And they gave it to the police in the area where Mary Beth lived in New Jersey. And the police came to the home of Mary Beth and said, well, you got to turn over the baby. But the order talked about the name Melissa. And that wasn't the name. Sarah was the name that Mary Beth had given the baby and the birth certificate. And she and her husband told the police, you got the wrong baby, you don't know what you're doing. And the police got all mixed up. And the two children were there, Mary Beth's children, you can't take our sister from us, what are you doing? And the police became confused and they left the house. And they didn't pick up the baby. Mary Beth and her husband then decided they were getting out of the state of New Jersey. And Mary Beth's parents lived in Florida, and she and her husband picked up stakes the next day, went down to Florida, and lived with her parents. To make a long story short, the Stearns got another court order. They sent it to Florida, and they got the baby this time 4 or 5 months later. And you had this lawsuit in New Jersey where the Stearns wanted the contract enforced. And the judge said that, well, during this trial, the baby should live with the Stearns. And in a way, that was unfair to Mary Beth, because once that occurred, and the baby was living with the Stearns, getting older, and so forth, the test was going to be the best interest of the child, and they were bonding. And the judge would not give Mary Beth Whitehead normal visitation. Said the visitation had to be with somebody watching and monitoring, because he didn't want her to take the baby again. But Mary Beth, it was at a center, a detention center in Hackensack, New Jersey, conscientiously visited the baby when she was allowed. I think it was about once a week, played with the baby. And in fact, the nurses at this home said she really got along swell with the baby. The two of them, she played, they were affectionate with each other. And this, in the long run, was very much favored Mary Beth, because she was bonding with the baby also. And then the trial eventually occurred. And during this trial, and I was there because I represented her parents who wanted visitation, but I was not the attorney. She had a very good attorney at that time, but she wasn't a good witness because she was so desperate to have the baby, and said things really she shouldn't stated, and maybe were inaccurate or untruthful, and she lost the trial. And then the judge, though, went a little bit too far. He said, Mary Beth, I'm terminating her as the mother, which was ridiculous, and in my opinion at least. And the Supreme Court did reverse that, and that Mary Beth can have no visitation at all, because all she's going to do is be trouble, and how you're going to trust her. And the Stearns were going to have custody. There was going to be no joint custody. And it was appealed to the New Jersey Supreme Court. It skipped the appellate division, and she asked me, after the Supreme Court reversed it, and the lawyer did, that if I would try the case to see whether or not she got visitation, because the New Jersey Supreme Court said surrogacy, with payment of money, is unethical, illegal, and we outlaw it. And Mary Beth can't be terminated as the mother. Nobody, if you had a divorce, she wouldn't be terminated. There's no reason. She did some things in desperation, but she seemed like a good person. And when she went to the visitation and so forth, sending it back to the trial below to have visitation. Now, before it went to the Supreme Court, I just want to briefly read something. The New York Times had a lot of articles, and so I wanted to have a quote from a column by A.M. Rosenthal in the New York Times, May 5th, 1987. He was a very important commentator, very, very important, and he said that Mrs. Whitehead descended into a public hell of exposure and humiliation to try to keep her child. This forced us all to face surrogate motherhood as an issue that touched our own beliefs and souls. For that she deserved respect, perhaps even a touch of gratitude, certainly not a judge's vilification. And I remember reading that column, and the New York Times, we know, was very powerful, and I said, she's going to win in the Supreme Court. And then we came to the trial, which she won.
Joel, that was all very, very interesting. Before, I want to thank you so much for coming on the show. Can you tell our audience 3 times your phone number or your email address and your email address so they know how to get in touch with you?
Okay, Joel Siegal, 973-621-9020, 973-621-9020. I'll say it one more time, Joel Siegal, 973-621-9020. It's One Gateway Center in Newark, New Jersey, right next to the railroad station.
Thank you. Now, I'd like you to summarize your views about 4 things. First, about sole custody.
Well, I think joint custody is the way to go. Makes both parents involved, and the parents, no matter how difficult a divorce they have, they should try their very best for the benefit of the children to get along and work things out nicely. So I very much favor joint custody, except if, in rare circumstances, one party just can't be a good parent.
What about parenting time?
Well, that has to be fact sensitive as to what the case is. But I agree that there should be liberal parenting time. I'm a little bit old-fashioned about visitation during the week. I don't know that it's so good to have the child go back and forth, be a ping pong ball. Weekends are different, but as the children go older, unless the other parent lives very close, there I'm still a traditionalist, and I believe the mother should probably be with the child.
And now the last one, about the outlawing of a woman being a surrogate for the birth of a child when such a woman receives payment for being a surrogate womb.
Well, I very much in favor of the change of the law. Most people, I think, aren't. I got vicious letters from people who adopted children. I've lectured on this at private schools in New York, where it's very interesting. All the children in the high schools, these are the best high schools, wanted the contract enforced.
Very interesting. Thank you so much, Joel.
Thank you very much,
for
Sandy.
coming on our show.
Okay.
We're out.
It's a little verbose, I think.
The questions were exactly what you wanted.
What?
The questions just followed the script.
Yeah.
No, I think you were fine.
I wanted to mention the cross-examination of Lee Salk. I didn't